This presentation will cover Chapter 11, Search and Seizure of Vehicles and Containers. Now, the courts have looked at vehicles differently than they do of other things that are not as mobile, such as your house or your business. But vehicles are inherently mobile. They're easy to move. And because of this, courts look at them different. So occupants of vehicles have a diminished expectation of privacy because things like the vehicles are traveling on a public roadway. They're generally not your permanent residence. They must be registered. You don't have an inherent right to drive any vehicle you want on the roads. Driving is a privilege, not a right. You do have to be licensed, and your vehicle has to be licensed and inspected for safety. Vehicles and how they are driven are also heavily regulated. How you drive on the road, the condition of your tires, your speed limit, stopping at stop signs. All this is all a regulated industry, so of course the courts are going to look at them differently than your private residence. There is an exception to the search and seizure requirements for vehicles. For an automobile, exception to the warrant requirement to apply, there are two criteria that must be met. First, an officer must have probable cause to believe that the motor vehicle contains illegal contraband. So you have that same level of probable cause needed to get a warrant, but you don't have to have the warrant because the vehicle is mobile and it could be moved. So you wouldn't have time to get to the judge to get the warrant. But you still have to have that probable cause that you would have, that you could present to the judge, get the judge to sign it. And again, the vehicle must be readily mobile, such as capable of being driven outside the jurisdiction. No additional exigent circumstances are required. So you don't have to say it's an emergency, someone's life is in danger. You just have to say the vehicle could have been driven off. I had probable cause to search it, and the vehicle could have been driven away, so I conducted the search. Now, the case of the vehicle in the photograph here up on its blocks, that vehicle is not mobile. You wouldn't be able to do a search without a warrant on a vehicle in this condition, or a vehicle that's disabled and unable to be driven. A search warrant is going to be needed if the vehicle is clearly not be used for movement, such as the picture you just saw, elevated or on blocks, or if the vehicle is located on private property and there's a time to obtain warrant. And again, the warrant must be based on a probable cause. So the same probable cause you need to search the car without a warrant, you also need to get a warrant if the vehicle is not mobile or if it's behind a fence on private property where you don't have access to the vehicle. Look at what's called the Carroll Doctrine. In this case, George Carroll and John Cairo were indicted and convicted for transporting in an automobile intoxicating spirits. Now this is going back to the Prohibition era, so, back in the 20s, before my time quite a bit. They had 68 quarts of so-called bonded whiskey and gin in violation of the National Prohibition Act. It is contended that the search and seizure of the gin were in violation of the Fourth Amendment, therefore you couldn't use them as evidence. They would have been disallowed as evidence because of an illegal search. And they were allowed, and Carroll appealed the case. Before the trial, a motion was made by the defendant that all the liquor seized be returned to the defendant who owned the automobile. That, believe it or not, that was denied because possession of alcohol was illegal. That'd be like the cocaine dealer petitioning the court to return his cocaine. Courts would probably deny that too. The search and seizure was made by federal prohibition agents and a state officer in December of 1921 as the car was going westward on the highway between Detroit and Grand Rapids. Facts leading to the search: originally in September, the agents were in an apartment in Grand Rapids. 3 men came to the apartment. A man named Krusaka and the 2 defendants, Carroll and the other defendant. The 3 men agreed to sell the agents gin and said they had to go to the east end of Grand Rapids to get the liquor and that they would be back in half to 3/4 an hour. They went away, and a short time later they came back and said they could not get it that night, that the man who had it was not in, but they would deliver it the next day. Well, the proposed vendors didn't return the next day, and the evidence disclosed no explanation of the failure, so they just didn't show up. Agents were later patrolling a road leading between Detroit and Grand Rapids and looking for violators of the Prohibition Act. They seemed to be part of their regular duty, kind of like a drug interdiction officer today sits out on the highway looking for vehicles to stop trying to get drug traffickers. They were doing it, same thing back in 1921, but looking for alcohol instead of drugs. On the 15th of December, some 2 months later, agents were in their regular tour of duty, were going between Grand Rapids and Ionia on the road to Detroit when Cairo and Carol met and passed them in the same automobile coming from the direction of Detroit to Grand Rapids. Government agents turned their car and followed the defendant to a point some 16 miles east of Grand Rapids, where they stopped and searched the car. They found behind the upholstered streets the filling of which had been removed and 68 bottles of alcohol. When an expert witness was called to prove the contents, defendant admitted the nature. They admitted it was whiskey and gin. When the defendants were arrested, Carol said to the agents, "Take the liquor and give us one more chance, and I will make it right to you." And then he pulled out a roll of bills, at least one of which was $10, which was a lot of money back in 1921. The officers were not anticipating that the defendant would be coming through the highway at the particular time, but when they met them there, they believed that they were carrying liquor, and hence the search and seizure and arrest. The opinion of the court was that the seizure is legal if the stopping officers are in stopping and searching the vehicles, they had reasonable or probable cause to believe that the contraband liquor is being illegally transported in it. So this is the first ruling in the favor of not having a warrant to search a vehicle when you had probable cause. Well, a delay in search and a warrantless search and a change in the vehicle's location may be permissible under the Carroll Doctrine. For instance, you're on a highway, on the freeway, and it'd be dangerous to search the vehicle, so you want to pull it to a safer location. Or if it's a situation where you have to get up under the vehicle because you have probable cause that their drugs are being hidden in areas that are sealed under the vehicle, you may be able to remove the vehicle to a mechanic shop to raise it up so you can search the area. But it has to be done without an unreasonable delay. So you can't take the car and hold it for a month and then search it. If you pull them off to the side of the freeway, go to a safe parking lot and do the search, or you bring it straight to the mechanic shop and do the search there. The scope of vehicle search under the automobile exception. Carroll searches allow for the search of anything, including containers and the passengers belonging within the vehicle that the officer has probable cause to search for a particular object. And again, this is a search based on probable cause, not a search incident to arrest where you're looking at the reach of where the driver could reach to grab something. In this case, you're basing it on probable cause and don't have the warrant only because the vehicle could move. So anywhere you have probable cause to search, the trunk, the locked box inside the vehicle, anything that is in there, you're okay. Now you wouldn't have that right incident to a lawful arrest because that wouldn't be something someone could reach in and grab right away. If the officer has probable cause to search only a particular container placed in the vehicle, the officer may search that container but not the entire vehicle. So if you have probable cause to believe that they've got drugs inside a blue knapsack that they put in the car, and you get in the car and you see the blue knapsack, you can search it, but you can't search the rest of the car. Now, if you arrest the driver, you could then search the area where the driver had access to, incident to a lawful arrest, or you may end up doing a vehicle inventory where you can search the entire car if you're going to tow the vehicle away. So there'd be 3 different exceptions to the warrant rule on that vehicle. One would be based on probable cause, one would be based incident to a lawful arrest, and the third one would be based upon an inventory of the vehicle. The Carroll Doctrine does not permit the warrantless searches of any movable container found in a public place. So, if it's a storage, container cargo or something like that, or a suitcase, that doesn't fall under the Carroll Doctrine. Closed containers and packages located outside of a vehicle may not be searched without a warrant or justification under some other exception to the warrant. So, if they pull them over and they throw the backpack out, you're probably going to need a warrant to search it, except maybe they abandoned it, which would be a different exception. So you kind of have to look at different exceptions. But you wouldn't be searching it under the automobile exception once they threw it out of the vehicle. And I just mentioned the impound and an inventory search. When you impound a vehicle, you will do a routine inventory of the vehicle and its contents, and that has got to be a department policy for you to allow you to do it. Most police departments have a policy that for the I guess mainly safety of the officers, and not physical safety, but to keep the officers from being accused of stealing something from the vehicle, or the record yard being accused of stealing something from the vehicle, because you're taking responsibility for it. You will inventory the entire vehicle and note any damage to the vehicle and any property in it. Now, anything that you find then will be in plain view because you have a right to inventory it. So if you see it, you can seize it. But again, it's got to be a department policy. And most departments are going to have policy, and they're going to have pre-printed forms that indicate what's searched in the vehicle, the condition of each section, what's found in each section. And the vast majority of the time, it's just an inventory signed by the record driver because he is now responsible because you're turning it over to him. And you're not going to find contraband the vast majority of the time when you tow a vehicle away. But if you do, you will be able to use it because you can legally do the inventory, and when you find something in plain view, then you can seize it under the plain view doctrine. When can the police impound a vehicle? When they impede traffic or threaten public safety and convenience. So, cars broken down on the road, we can tow it away. If you're in a wreck and your vehicle is disabled, we can tow it away. When the driver or the owner are taken into custody or incapacitated. So if the driver has a medical emergency and they take him off to the hospital in an ambulance, we're going to probably tow the car away and not leave it on the side of the road where it could be vandalized or damaged, and we can inventory it. If we arrest the driver, we can tow the vehicle away. We arrest a passenger, that's not going to allow you to tow it. But if you arrest the driver, you can. If the driver has no insurance or license, we can't let him drive it off, so we could tow it away. If you're seizing them as evidence of a crime, car was used in a bank robbery, we're going to seize the vehicle because it was a bank robbery. If it's been reported stolen, obviously we're not going to leave a stolen car on the side of the road, so we'll seize it under those conditions. And then if it's been forfeited to the state because it has been subject to some kind of seizure laws, either because it was used in a drug crime, it was purchased with drug money, it was used in a bank robbery, or some other felony offense where you have a legal right to seize the vehicle. And the inventory seizure, the stated purpose is to protect the owner's right to protect the police against claims regarding lost or stolen vandalism, or to protect the record drivers for the same, and protect the police for potential dangers. We once had an officer who got an unpaid vacation for a couple of days, who arrested an individual and had his car towed away. I believe it was over Mardi Gras or one of those events that was going on. This was in Dickinson. The record company that towed it away actually towed it and put it inside their garage. And early the next morning, one of the mechanics goes in there, and a guy gets out of the back seat of the car and says, "What are you doing here?" Well, he was drunk, passed out on the floor of the back seat, and the officer who inventoried the car didn't notice one drunk passed out on the back seat on his inventory. So obviously he didn't really inventory it like he was required to. He just kind of filled in the blanks and left it like that. So when you inventory, you really have to check these areas. You never know whether there's a drunk in the back seat or not. And again, a valid inventory search doesn't need probable cause, and it doesn't need a warrant. You're not conducting a search per se. You're actually inventory the vehicle, and again, what you find falls under the plain view doctrine. Well, this inventory, as I've already mentioned, has to be a standard procedure. The inventory must be conducted within the guides of your standard procedure. It's got to be in your department's standard operating procedure or rules and regulations or whatever you want to call them before it can consider it a legal search or a legal inventory. The procedure must be reasonable and be administered in good faith. You can't just use this inventory when you suspect there's something in a vehicle. You have to do it all the time. So you have to inventory the vehicle of everybody you arrest, not just when you arrest a drug dealer. It doesn't work that way. It's got to be a standard procedure that you follow. Inventory searches are given or based on the department procedures. Based on the procedures, courts have upheld inventory searches of things like the passenger compartment, the glove box, the trunk, the engine compartment, and closed containers found within the vehicle. Again, the purpose is to safeguard the rights of the person being arrested or of the rights of the person whose vehicle is being towed away. So you're going to inventory it to see what's there, so that they can't come back and claim that the officer took something, someone stole from them. So that's the whole purpose of it. So you have to search everywhere. You have to look in the trunk. You have to know what's in the trunk. Don't know too many that do a inventory under the hood, but if that was your department policy, then you have to do that. Now, if you don't check under the hood as a part of the department policy, you can't check under the hood of a vehicle just because you suspect they've got drugs hidden in there. So you still have to follow your department policy. And absent any emergency circumstance, an inventory search of a vehicle must be conducted at the time of impoundment or shortly thereafter. Again, if you're on the freeway and there's traffic going around and it's dangerous, and you can get the wrecker there and you can hook up and you can pull over to the parking lot right next to the freeway and then conduct your search and inventory of the vehicle, not your search, your inventory of the vehicle, that is permissible. But you can't do the inventory of the vehicle 2 days later or several hours later. You have to do it pretty much before the vehicle leaves your sight, where you can say, I'm doing it for my protection. The vehicle's already been at the wrecker yard for 2 days. You can't say what happened to that vehicle. You can't say that something was added or something was already taken out. The inventory searches are not done to search for contraband, and as I said, but you have a legal right to be there to do the inventory. Therefore, if you find it, it's in plain view, and you know the plain view doctrine allows you to confiscate it and use it for evidence. In order to challenge a search that is done under the Carroll Doctrine, you have to have legal standing. And by this, you have to have a right to expectation of privacy where you're at. A vehicle occupant must have a reasonable expectation of privacy in the area of the vehicle that is being searched. So in the passenger, if your passengers in a vehicle generally have no right or expectation to privacy in somebody else's vehicle. Passengers may challenge the stop, but they're going to have to say why they have a right to privacy in somebody else's car, which you generally don't. You have a right to privacy in your own home. You don't have a right to privacy in my home. Well, as technology advances, the way we look at things, where the court looks at things, has also can be changing. We'll talk about tracking vehicles using electronic devices. The old system, it was kind of like a beeper system, and you actually had to have at least 2 cars out to kind of follow the person, with a stronger signal, and it wasn't real quick and easy like it is today with the GPS devices on vehicle. The courts have held in the past that because the car's on a public right-of-way and you're not taking any really, invasive measures to attach it, because most of them were attached with just a magnetic thing. You walk by the car and you snap them on, that you didn't need a warrant or emergency circumstances to install the GPS device on the vehicle. But again, you couldn't go into their house or into their garage to do it, but as long as you did it on a private street, there was no problem. The times are changing, though. And we're going to talk about one case. This was the case from 2012. in United States versus Antone Jones. Jones was convicted of trafficking, drug traffic and conspiracy charges. The district court suppressed the GPS data from the vehicle parked outside the respondent's residence, but held the remaining data admissible because the respondent had no reasonable expectation of privacy when the vehicle was on public streets. But in his own driveway, he did. The district D.C. Circuit Court reversed it, concluding that admission of evidence obtained by a warrantless use of GPS devices violated the Fourth Amendment. And the court held that the court's installation of the GPS device on the target vehicle and the use of the device to monitor the vehicle's movement constituted a search under the Fourth Amendment. Accordingly, the judgment of the Court of Appeals eventually was affirmed because they entered on private property. So it's something that we could do in the past, but can't do as much in the present. And in another case, in the United States versus Harry Katzen, Michael Katzen and Mark Louis Katzen, and again, this is in a U.S. Supreme Court. It's the Third Circuit Court of Appeals case. The Katzen brothers were suspected of a multi-state pharmacy burglaries. So the FBI attached a tracking device to Harry's car. I believe it was a van-type vehicle. And they were able to follow the brothers and were able to make them on the burglaries because of their locations at the times the burglaries were committed. The third court held that they have no hesitation in holding that the police must obtain a warrant prior to attaching a GPS device on a vehicle, thereby undertaking a search that the Supreme Court has compared to a constable concealing himself in the target's couch in order to track its movement, or the target's coach in order to track its movement. So because of the GPS devices, I guess you don't have to physically follow it. The courts are kind of looking at them differently than the beeper device, where you actually had to physically be out there to follow the vehicle. It just helped you keep track of where the vehicle was at. Now we'll talk about vehicle searches with a dog. The use of specially trained dogs to detect smell of drugs in vehicles is not considered a search under the Fourth Amendment. If the dog alerts on the presence of contraband, then you have probable cause to search the vehicle. And remember, if it's a vehicle on the road, you do not have to have a warrant to search a vehicle as long as you have the probable cause, and you will have the probable cause. Now, this is, again, if the vehicle's on the roadway. I have some questions if the vehicle would be in their private driveway. And what brings the question to me in the case of Florida versus Jordanus, which was from March of 2013, with the narcotics officers in, I believe it was Miami, actually brought a drug dog onto someone's property and past their front door, where the dog sniffed and alerted. They got a warrant to search the house, but the courts held that the fact that the dog was sniffing odor coming from inside the house was a search. So you would have had to have a warrant to bring the dog up to the front door to sniff it, which would have given them probable cause to get inside. So you can't do that. And I think if the car was parked in their driveway, the courts may look at that similar, because you'd have to trespass onto their, or not necessarily trespass, but you'd have to step onto their property to have the dog alert on it. So again, there hasn't been that court decision yet, but I would be leery of bringing the dog onto their private property to walk by it. Now, if they're parked in the parking lot of an apartment complex in a common area, or in front of a business where generally people can walk by, you'd probably be okay there. Well, that concludes this presentation. Next up, we'll be looking at open fields and abandoned property in Chapter 12.